Good afternoon. Your name, sir?
David Walker.
Your Honor, it looks like he has two files.
I see that. All right, we'll next take up two cases, both entitled State of Kansas versus David Wayne Walker, 22 CR 398 and 22 CR 508. All right, we'll first take up 22 CR 508. This is my case, Mr. Walker. You failed to appear in front of me on July 17th for your preliminary hearing control docket. Where were you that day? Okay, well, I issued a bench warrant bond forfeiture and set a new bond in the amount of $10,000 cash or surety. Are you still representing yourself?
Yes, sir.
You want to continue representing yourself?
Look at me. I'm not looking at you. I'm looking at the paper. Yes, sir. Don't have any money to.
Pardon?
Yes, I guess I'll represent myself.
Okay, you understand that if you can't afford to hire an attorney, one would be appointed for you.
I don't know what he would do.
Welcome back to Courtroom, where real-life justice meets pure chaos. Today, we got a Kansas sovereign citizen named David Walker. And trust me, this guy is about to turn a basic court appearance into a circus act. He's facing two separate criminal cases, both serious, yet somehow believes legal magic words and pseudo-law YouTube videos are going to save him. Spoiler alert, they won't. From refusing an attorney to claiming no victim, no crime, Walker delivers a masterclass in courtroom confusion. And just like that, Walker's juggling two active criminal files, not traffic tickets, but full-blown felony cases. The judge tries to keep things orderly, but you can already sense a storm brewing. What's wild is that Walker isn't just facing one mistake. He's built himself a pattern of failing to appear, ducking responsibility, and somehow believing that representing himself is a power move. But as every courtroom junkie knows, self-representation is the fastest route to self-destruction.
Okay, well, he could provide you legal advice and perhaps advance any defenses you may have had, but if you want to represent yourself, you have that right. I just want to make sure you understand that if you can't afford an attorney and would like to have one represented you, I would appoint one for you. Do you understand that?
Yes, sir.
And you wish to continue representing yourself?
Yes, sir.
The docket notes don't reflect if a waiver of counsel was ever signed. Do you have any notes that would reflect that he's waived counsel on the record or otherwise, Ms. Norris?
Your Honor, I just note that on December 30th of 2022, defendant stated that he would hire his own counsel.
At this point, the judge is practically handing him a lifeline, a free attorney who could guide him through the chaos. But Walker shrugs it off like he's being offered a coupon he doesn't need. Here's the thing. Refusing counsel isn't a flex. It's like walking into a chess match against a grandmaster while you're still learning how the knight moves. And when he says, "I don't know what he would do for me," you can almost hear every public defender in America collectively sigh.
And then he had a failure to appear. And on May 5th, we did not appoint any counsel. I don't show an actual waiver. And the notes don't reflect that he did a waiver on the record. It just says that he would hire his own attorney.
Okay. Well,
Okay.
Mr. Walker, you've indicated here on the record that you wish to waive your right to an attorney and represent yourself. So I'm going to have you, if the jail has one, sign a waiver of counsel. Do you have a form?
I believe so.
All right. Can you read through that? Make sure you understand it. If you have any questions, be sure to ask me.
There is no defendant in the. I'm the defendant in the case. Am I the defendant?
When Walker starts asking if he's a defendant, you just know where this is headed. He's trying to separate himself from his legal fiction, that bizarre idea that the name on the court file isn't really him. The judge's patience at this point deserves an award. Most people would have hit the gavel and walked out. But he keeps explaining, step by step, like a parent helping a toddler with homework. This is courtroom deja vu for anyone who's seen these arguments fall apart 100 times before.
There's no victim. There's no victim to my crime, correct? The crime that I'm accused of, there is no victim in the crime.
The state of Kansas, you have drug charges, possession of methamphetamine, possession of paraphernalia, and driving while suspended are your 3 charges.
Yeah, but no victim, correct? No victim in the crime.
I'm not sure I understand your question and what that has to do with your waiver of counsel.
Well, I'm the defendant. There must be someone making a claim
The state of Kansas is making the charges against you, Mr. Walker.
the state of Kansas is the victim.
The state of Kansas charged you with these crimes. Do you wish to represent yourself or do you wish to have an attorney representing you?
I will represent.
It sounds logical until you realize most crimes don't need a physical victim. Drug possession, suspended license, DUIs, all are offenses against the state, not against a person. The judge even spells it out. The state of Kansas is a victim. But for Walker, logic isn't the problem. It's ideology. He's not arguing to win the case. He's arguing to feel right. And that's why sovereign citizens always lose. Reality doesn't bend to belief.
In front of you, correct?
Yes, I suppose so. Why do I need to sign? Why do I need to sign it? Why do I need to sign this?
Because I like to have it documented in the file that you understand that you have a right to have an attorney representing you. And that if you can't afford to hire one, one would be appointed for you. And you understand that, and knowing those rights, you wish to represent yourself. That just documents that for the court file.
What I don't understand is why there is charges against me when there is no victim.
All right, Mr. Walker, I'm not going to play this game this afternoon. I'm going to set this case
Why are we playing a game?
in front of me on
I'm asking questions. I'm really asking questions.
October.
This is where the tension peaks. Walker refuses to sign the waiver of counsel, asking, "Why do I need to sign this?" It's a legal safety net, proof that he willingly gave up his right to an attorney. But in his mind, signing means submitting to the system. You can see the frustration on the judge's face as he tries to explain for the 5th time. This is just documentation, not a trappy irony. The same people who scream about their rights often refuse to sign the paper that protects them.
Your case is being set on October 10th at 2:30 in front of myself, and that will be done by Zoom. That's the felony preliminary hearing control docket, October 10th at 2:30.
Your Honor.
You've got a $10,000 cash or surety bond on that case.
Yeah. I was wondering if I would be able to have access to certain legal things to be able to.
It's a pivotal moment, the point where a judge transitions from educator to enforcer. You can feel the shift in tone. The kindness fades and the system reasserts itself. Walker thinks he's challenging authority, but in truth, he's proving exactly why courts exist, to separate personal fantasy from legal fact. By the time the judge resets the date and mentions Zoom, you can almost hear the unspoken good luck genius.
They've got a law library there at the jail. I'm not sure what kind of access they provide to you, but you can consult with somebody there at the jail.
Okay.
All right, I'm now going to take up 22 CR 398. This is Judge Webster's case. Looks like he failed to appear in front of her on July 31st. She set a new bond for $6,000 cash or surety. You've already had a first appearance, so I'm going to set this in front of Judge Webster on October 30th at 9 o'clock in the morning. That will be by Zoom, October 30th at 9 o'clock in the morning. So again, your bond is $6,000 cash or surety. Anything else on this case, Ms. Norris?
No, Your Honor, thank you.
Your Honor, was the time for court on October 10th for 22 CR 508, was that 2:30?
That's correct.
Just clarifying. Thank you, Your Honor.
All right, we'll be in recess. Mr. Walker, you are excused.
2 separate criminal cases, multiple mishearings, and a masterclass in how not to handle your defense. The judge handled it with patience, precision, and a touch of professional restraint. Something not every judge could maintain under these circumstances. When you walk into court with TikTok law and YouTube logic, you don't walk out with freedom. You walk out with another bond and a new court date. If you found this case as shocking or hilarious, as we did, hit that like button, share your thoughts below, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.